Next topic, I-824s. This is something I talk about on my my consumer podcast for JK Law Firm all the time, pretty much nowadays. And I'll bring it up probably here a lot here, but it's such a big problem. It's not information as the I-824. It's a badly designed form, and kind of annoying that it's necessary. So essentially, there's different scenarios where it pops up. A lot of times, I'm getting is people file Form I-130 and they mistakenly apply adjustment of status when their spouses or family members overseas, so they have to do consular processing. So this submit I-824 for that. It might be a case where mom's here, they get their I-130 approved, their child's overseas. You have to have submitted I-824 for the rest of the case to do follow to join. That kind of stuff happens, especially employment-based. So someone here gets their employment-based green card, their spouse was in India, for example, and then they have to do follow to join and submit I-824. Problem with I-824 is it could take 3 months, it could take 2 years. You might have to do a lawsuit to get them to do the job right. So that's a problem. But one particular problem I keep seeing, and it's particular from the bigger law firms. I have people, when we have these big corporations that do like 10,000 EBs, they go to the big name law firms, and by big name, it's just volume wise that they handle. And I keep having the applicants not believing their lawyer that the company provided and coming to me and then telling me that they're being told that for the I-824, you have to wait for your I-140, I-130 adjustment, whatever it is, to be approved. Then you can file the I-824. But that's completely incorrect. The rule is that you either file the I-824 with the application for adjustment of status, or you file it afterwards, after it's approved. I think you're not supposed to do it while it's pending. But you really want to do it with the adjustment of status, because that's a way to lock someone's age in for the Child Status Protection Act if there's kids. Like I had this one woman, she was Indian here, EB2, and her lawyers at the big firm said, can't file I-824. She came to me and I found the citation to the USCIS policy manual. I said you could file the I-824 with the I-485. And the importance of that is it locks the child's age in for Child Status Protection Act. And this child was like a month before the age 21, and they were going to age out by the time the I-485 is approved and they take action on the case. A complete malpractice, frankly. But we're able to save them on that. So that was good to do. And the other aspect of it is I-824 to take forever. So you just want it in the system as soon as possible just to get it adjudicated. Now, if you do get the I-485 approved and the I-824, they send it back, stamp it, saying like filed and accepted, this and that, you still have to call them and remind them to do the process of sending the case out, because the USCIS will forget, and you got to call them like a million times sometimes. So it's a mess of a form, mess of a process, but it's just something you got to do for clients. So prepare for that.